What I think it is fair to describe the government as doing is shifting from a policy where it would go after those who have done something wrong. Shifting from that to a policy where you go after people you think may do something wrong. So it's shifting from a policy of punishment to a policy of prevention. And while that may make some sense, if there are certainly reasons why one would want to prevent bad things happening as opposed to punish the people who've done them, it brings with it a deeply troubling set of new policies that are, in my view, very dangerous to civil liberties and to values of justice and the like. Because when the government doesn't have evidence, when the government doesn't have proof of the bad thing that a person is alleged to have done, they need to find something else. They need to find something else to demonstrate that person can be punished. And so instead of relying on clear and unambiguous evidence of wrongdoing, what the government is increasingly doing is looking for things that it takes as proxies of badness, things that it takes to stand in for being a bad person. And often those are things that are innocuous, but they're things that are linked to Muslims or to religious practice. And so there is a danger with this preventive paradigm that the government, in trying to do something that may at some level be legitimate, end up adopting essentially a set of discriminatory and deeply biased policies. And this may sound obvious, but let me spell out sort of four angles or four ways in which this preventive paradigm is now playing out and changing public policy. And you'll see that I hope that the Hashmi case is sort of one of several trends that we are seeing that all make sense when you look at it from the perspective of thinking about, well, what is the government trying to do? To the first trend, or the first sort of aspect of this preventive paradigm, is the increasing use of immigration law. And I'm sure many of you are aware of the NCIS program, which was the immigration program that was adopted in 2002 that required nationals of essentially Muslim majority countries and North Korea. There's numerically an insignificant number of North Koreans in the United States, so that was a meaningless inclusion. To register with the immigration services. A staggering number of people who registered were deported. This was seen as a way, essentially, of pulling in as many Muslim immigrants as possible and essentially deporting as many people as you could in a relatively short time frame. The NCIS program is formally over, but there are two important respects in which its legacy is very important, is still salient today. The first is that there are about 12,000 people who have outstanding orders of detention as a consequence of NCIS. And the second is that while the government is not enforcing NCIS today, while it's not requiring immigrants from majority Muslim countries to register on an ongoing basis, the legal framework for NCIS, which is embodied in a set of regulations the Department of Homeland Security has issued, the legal framework still exists. So with the click of its fingers, the government could reimpose that, reconstitute it again. So it's not that NCIS has gone away, it remains, one might say, in suspended animation. So that's, and both of these are, or NCIS and sort of what might follow from it, is a first example of an approach which is preventive. You're not interested in stopping, in capturing people who have actually done something wrong. You're interested in acting preventatively. And instead of looking for people who may commit violence, you take religious identity or national identity as a sign that somebody may be at a risk. The second way in which the preventive paradigm plays out is in surveillance. And this is an area where we obviously don't know a lot of details about what's going on. But from the debates that are happening now in Congress, we have a sense of the general direction. Some of you may have read recently in the newspapers there's been a debate about a law called FISA, the Foreign Intelligence Surveillance Act, enacted in the late 1970s as a restraint on the government's ability to spy on people for national security purposes in the United States. Since 9/11, the government has been violating FISA wholesale. When that was discovered, there was a debate in Congress about what to do. Essentially, the debate was hijacked by the administration, who forced through in August 2007 a temporary law called the Protect America Act. And the Protect America Act essentially authorized the illegal spying that had been going on since 2001. Protect America expired. It was a temporary law. Protect America expired on February the 15th of this year. And the debate now is about what will follow from that. But what's key, or what's worth focusing on for this purpose, is the kind of new surveillance power that's given by Protect America and the new version of FISA that is being debated in Congress. Essentially what this new statute does is to get rid of the requirement that the government have a warrant for any individual spying decision. The government now no longer needs warrants. What the government can do is simply write itself a blank check. That's not quite right, but the government can write itself authority to spy on any class of communications that are international. So anytime you're communicating with somebody overseas, it is feasible for the government to pick up that communication without an individualized warrant. And in fact, if you read the law, it's very clear that it's much easier for the government to get authorized under the law a sweeping blanket capture of communications than it is for it to get individualized grabs. So this shift in electronic surveillance, I think, or the shift in the law, I think is being driven again by the preventive paradigm. What the government is interested in is no longer trying to pick out individual people. It's interested in simply sweeping in, say, all communications to Pakistan, all communications to the West Bank or the occupied territories. And that's in likelihood, it's very likely that that is the kind of surveillance that is now going on. So again, it's being driven by this preventive paradigm. The third thing is the preventive prosecutions. And, well, I say preventive, but you should take that with a heavy dose of salt. And Sean's really, I think, going to talk about that and give you a bunch of examples. But this is the very aggressive use of a set of laws called material support laws, the laws around terrorism financing under a statute called the IEPA, the International Economic Emergency Powers Act, that allow the government to prosecute individuals with very, very little evidence of actual harmful wrongdoing. These are quite astonishing laws when you actually look at their content, and you can sort of draw them back historically. Or they are the successors to a set of laws that were passed in the 1930s, essentially to go after the mafia. Where you didn't have any evidence that somebody was actually in the mafia, so you got them on something that was tangentially related. So it's the same kind of sort of attempt to sweep in a broad category of people. The final thing to put on the table is something that doesn't exist yet, but I think that you should all be aware of it, and you should be looking out for it because it's something that may emerge in the next 6 to 8 months, and that's preventive detention. Preventive detention is when you seize people and you not under the military law, but under civilian law, you detain them for weeks, months, it varies from different places. And this is now, in the last 4 or 5 months, we've started to see this being talked about at relatively high levels of the government. We've seen Gonzalez, before he resigned as Attorney General, moot the possibility of a preventive detention scheme like the one that the United Kingdom has. Michael McCasey, the new Attorney General, has said very, very similar things. There is a conservative think tank called the Hoover Institute that is funding a set of studies that will appear in a number of different places. And you're already starting to see Hoover Institute funded op-eds, but all of which, these studies and op-eds, are arguing for some form of preventive detention. So what we're seeing is the beginning of a concerted campaign to get legislation passed that would allow the government to seize people and preventatively detain them.